Hi, my name is Mike Landers with L7 Marketing Solutions, and I'm here today to interview Larry Wolfish, attorney at law, on the subject of revocable trust and irrevocable trust, their differences, and when to use them. Larry, I want to thank you for taking the time to meet with us today.
Mike, I appreciate this opportunity, and I'm glad to help.
We thank you, Larry. And Larry, the first question I wanted to ask you in layman's terms, what exactly is a revocable living trust?
Mike, a revocable living trust is a legal document that permits people to transfer their property by trust law, allowing for a mechanism for the management of their assets not only while they're alive, but also to transfer their assets when they someday pass away.
Really, Larry, who needs a living trust and why?
You know, oftentimes people need a revocable living trust because they've got property out of state and they want to avoid ancillary probate. They want to create a mechanism for the management of their assets while they're alive, knowing and understanding their will is only going to transfer their assets at date of death. People are interested in privacy, the confidentiality of their assets. People use it for any one of those reasons.
Could you explain real quick the difference between a revocable and irrevocable trust, Larry?
Sure. When a trust is irrevocable or irrevocable, that means it can never be changed. Its terms and provisions are cast in stone and can't be changed, except perhaps for judicial modification by a court. But a revocable trust permits people to make changes periodically over the course of their lifetime and only becomes irrevocable when they pass away.
Larry, in your practice, has there ever been a time where you've had to do both a living trust and an irrevocable trust?
You know, oftentimes people want to create trusts for their children. The law permits them to make tax-free annual exclusion gifts. People want to own life insurance policies but don't want the proceeds to be part of their estate. Oftentimes an irrevocable trust is used to minimize the size of a taxable estate, allowing assets like life insurance or stocks that are going to grow in value to grow outside of their estate and to be used solely for the benefit of the named beneficiaries and not shared in the form of taxes.
Great. And you know, Larry, it brings up another question. If somebody has a trust, do they also need a will?
Absolutely, because a will is a document, a conveyancing document that transfers property from one person to another that only takes effect at date of death. And oftentimes if people create a revocable living trust, even if they do everything they can to transfer their assets to the trust before they die, sometimes there's overlooked assets. Could be a federal income tax refund, but there could be overlooked assets, and the will pours over to the trust any assets that were omitted from the trust originally.
If somebody doesn't title their assets in the name of their trust, can you tell us what happens at that point?
Sure. If they have a will, the well-drafted will would typically simply name the trust as the destination for those assets, and the assets would simply pour over to the trust. If they don't have a will whatsoever, they only have a trust, then state law will decide to whom those assets will someday pass.
You know, Larry, there's a lot of confusion about having assets titled under your trust. Does having a trust protect them from creditors in nursing homes?
It really does not. The Texas law looks upon a revocable living trust, a trust that they can create, a trust that they can name themselves as the beneficiary, a trust that they can name themselves as the trustee, is really being their alter ego. And the Texas law does not permit someone to create a trust and to shield their assets from their creditors if that trust is revocable.
And that brings up this last question, Larry. Does a trust save on any income taxes or any taxes at all?
It really does not. As a matter of tax law, we treat a revocable trust as a grantor trust, and all the income of the trust simply belongs to the grantor and is reported on his or her Form 1040 each year.
You know, Larry, you've provided us with a lot of great information today, and I'd ask, do you have any closing thoughts or advice that you'd like to give families about estate planning in general?
I think a lot of estate planning is about asset protection planning, allowing people to protect their property not just from taxes but also from third parties. And basically estate planning is for people that want to decide for themselves how their property passes and who it passes to. People don't oftentimes need an estate plan with respect to the transfer of their property. The legislature will say how the property passes if people don't, but many people want to exercise control and make those decisions themselves rather than letting the legislature make those decisions. But oftentimes a well-drafted estate plan takes into consideration not only what happens after someone passes away, but before they pass away, and it gives people the opportunity to make those decisions with respect to the management of their property or the management of their person for healthcare decisions.
Larry, I want to thank you again for taking the time out of your schedule. And if somebody has a question, how can they contact your office?
Our office number is 972-248-7448.
And do you have an email address, Larry, that they can get you to?
We do. It's L Wolfish, like Larry Wolfish, at wolfishlaw.com.